Thank you. Mr. Elliott was picked up on a tether violation, it says, on the 4th. For the life of me, I cannot figure out what the tether violation is. I read this record, this report here, and it says that he was over there lurking at the police department.
Judge Michael McNally looked down at the paperwork in front of him and said the words out loud, almost to himself, "For the life of me, I cannot figure out what the tether violation is." A man had already spent nearly 2 full days in a Wayne County jail cell over a violation nobody in the courtroom could actually name. The deputy who arrested him couldn't explain it. The report that triggered the arrest didn't explain it either, and the only person who seemed to know exactly why the defendant had been standing at that police station in the first place was the judge himself. Nobody said that part out loud yet. By the end of this video, you'll understand exactly how a GPS ankle monitor can technically tell the truth and still put an innocent man in a jail cell. On February 21st, 2023, a man identified in court only as Mr. Elliott was arraigned in Michigan's 33rd District Court on a domestic violence case stemming from an alleged incident on January 27th. Because the case was still pending, nothing had been proven. Elliott was released on bond under GPS monitoring, barred from contacting the alleged victim, Isabella Cavalin, and ordered to stay 2 miles from her home and workplace. On April 4th, Judge McNally noticed Elliott still hadn't been fingerprinted and ordered him, under MCL 764.29, to report to the Woodhaven Police Department to fix it.
Rising from an alleged January 27th incident, because the case remained pending, the allegations had not been decided. Elliott was released on bond with GPS monitoring and restrictions designed to protect the alleged victim and prosecution witnesses. Section 765.6b of Michigan law permits GPS monitoring in certain domestic violence cases, but a location becomes a violation only if it breaches an actual bond restriction. On April 4th, Elliott appeared before Judge Michael McNally. His fingerprints were missing, so McNally ordered him to report to the Woodhaven Police Department. Section 764.29 permits that instruction. At approximately 7 o'clock that evening, Omnilink placed Elliott at the police department. A report later read aloud in court said the Tether unit confirmed his location, emailed a detainer, learned he was there for fingerprinting, and referred to a Third Circuit warrant. Elliott was taken into custody. By the time he returned before McNally, he had spent approximately 38 hours in jail over a supposed tether violation, but the report named no condition he had broken and said Elliott was compliant with his curfew. The location that triggered the investigation was the police department McNally ordered him to visit. A GPS record can show where someone went, but not why. Police contact, a detainer, a warrant, and a tether violation are different legal events. McNally must determine whether any valid hold justified Elliott's detention, or whether he was jailed for following the court's own instruction.
Woodhaven.
Elliott wasn't a stranger to the system, and he wasn't hiding from it either. He was a man working 2 jobs, trying to keep both, while an unresolved criminal case hung over every shift he showed up for. A pending felony doesn't just cost attorneys fees and court dates. It costs employers patience. By the time he stood in front of McNally again, he told the court he'd already lost 1 job because he'd been locked up.
I figure out why this gentleman is in custody.
I have a job.
Mr. Elliott, I'm going to straighten it out for you, sir.
Thank you. I'm really thankful.
He's working 2 jobs. He's stressed because he's going to lose his job.
I just lost my old job because I got locked up.
All right.
38 hours in custody isn't an abstraction to a man clocking hourly wages. It's a missed shift, a missed paycheck, and a conversation with a manager he can't take back.
Yes, I did, Your Honor, because you told me to.
Right.
Yep. And I didn't know I had a tether violation, and they arrested me. And also, I need to pay a ticket
Slow
today.
down. Slow down.
Sorry.
Slow down. Let your lawyer speak.
I see a warrant. I see he was picked up on a warrant while being fingerprinted out of the Third Circuit in Wayne County.
Do you have is there a deputy right there?
Yeah.
Deputy, can you come back up here, please, and state and spell your name for me?
My name is Officer Marquise Rigel, Marquies. Last name Rigel, Ridgell.
That evening at the Woodhaven Police Department, Elliott's GPS tether, an Omnilink monitor, pinged his location to the sheriff's Tether unit. A sergeant reviewing the ping contacted Woodhaven, confirmed Elliott was physically there, learned he was being fingerprinted, and then noted that a Third Circuit warrant had turned up in the system. A detainer was emailed. Elliott was taken into custody on the spot and classified into holding status. On paper, that reads like a clean chain of law enforcement doing its job. A monitored defendant, a location confirmed, a warrant discovered, an arrest made. Nobody in that chain stopped to ask the one question that would have unraveled the entire thing: why was he there? Most people watching a report like that would read warrant and assume guilt. That single unexamined word is what kept a man in custody for 38 hours.
He's being fingered.
I noticed the above subject tracing the location of the Woodhaven Police Department. I contacted Woodhaven Police, did verify subject was there. A detainer was emailed. I was notified the subject was at Woodhaven Police to be fingerprinted. A Third Circuit warrant was found and the subject was put into EMU writ status. So this has nothing to do with him. Him being in custody right now has nothing to do with a tether violation. Is that true or false?
I'll have to look, sir. Hold on.
I don't see any reference in there about a tether violation.
Well, it says it in here. There was. I mean, implicitly they say it, but I don't see where there was one. I didn't order him not to go back to the Woodhaven Police Department. I think he was picked up on another warrant.
Here's what almost nobody watching this hearing catches on the first pass. The location the monitoring officer flagged as suspicious wasn't a location Elliott chose. It was the location Judge McNally had personally ordered him to visit 9 days earlier. The suspicious data point was compliance, not evasion, and it passed through an officer, a sergeant, and a jail intake process without a single person cross referencing it against the court's own record.
There is reason to believe, and I'm going to state it, not my client. And Mr. Elliott, I don't want you to say anything because you haven't pled guilty to anything and you're presumed innocent. I have reason to believe that maybe there was a battery not charged when he was at home. That may be an issue.
Excuse me, Your Honor.
Yes.
According to the system, it says he says for malicious destruction and 2 counts of domestic violence. Now, about that report or being a violation of his tether, I would have to even read the report myself, sir. I didn't write the report.
Under Michigan law, GPS monitoring in domestic violence cases is authorized by MCL Sim 65.6b, but a location only becomes a violation if it breaches an actual specific bond condition: no contact with the alleged victim, no presence near her home or job, adherence to a curfew. A GPS ping simply shows where a person's body was. It does not, on its own, establish that any court order was broken. That distinction matters because Michigan pretrial detention is supposed to rest on a violated condition or a valid active hold, not on an officer's inference about what a location probably means. The question the record needed to answer and didn't was simple: did anything Elliott actually did breach a condition of his release?
Can I speak?
You're just, Elliott, I want to make sure you don't say anything that incriminates you because you haven't pled guilty to anything.
I know I've been told 4 different things that it is. Like, I don't know what I'm
That's fine. What is it that you're being told?
I'm being told from the sheriffs that picked me up from the Woodhaven Police Department, it was a tether violation. Then when I first asked the Woodhaven Police Department, when I first got there, they told me it was a stalking charge. I've never stalked anybody. Then now it's a malicious destruction of property, which I'm paying off. That's from another case at Woodhaven that I'm paying off. And I need to pay that ticket off today as well, which is another problem for me, but that's beyond the point. So basically, I'm very confused. My tether got it. I know it's a tether violation, but I don't know. I'm sorry, Your Honor. I'm not trying to confuse
All
you
right,
either.
slow down. Just relax.
We're all trying to figure it out together.
Take a deep.
What followed in court functioned like a cross-examination of the paperwork itself, with McNally playing prosecutor against his own system.
breath.
The confusion in this exchange comes from several different processes being treated as though they prove the same thing. A GPS alert can tell a monitoring officer that a person entered a particular location. It does not by itself explain why the person was there or establish that a bond condition was broken. A police contact simply means there was an interaction with law enforcement. A warrant, if valid and active, can authorize an arrest. And a detainer tells a jail that another authority may have a reason to keep someone in custody. McNally's problem is that the record mentions all four concepts without clearly connecting Elliot to a confirmed violation or active hold. An unrelated allegation is also raised, but the judge prevents Elliot from discussing it because it has not been adjudicated. The court now has to test each possible explanation against the records: Elliot's curfew, his other cases, the alleged police contact, and any current warrant that might justify the detention.
Relax.
He called the deputy to the podium and had him spell his name for the record. He read the report aloud, line by line, and asked directly, "Does this have anything to do with a tether violation?" "I'll have to look, sir," the deputy answered. McNally kept going. No curfew violation was documented. No new charge had been filed anywhere in Wayne County's system. The only concrete thing on paper was a phrase, police contact, vague enough to justify almost anything and specific enough to prove nothing. Then came the moment that reframes everything. McNally revealed that he was the one who had ordered Elliot to that police department for fingerprinting on a completely separate procedural matter. The warrant evaporated into an unrelated old case already being resolved. In the real world, this is the difference between a man walking out of a courtroom on his own bond and a man sitting in county lockup for the better part of 2 days over a data point nobody bothered to verify against the court's own file. A properly functioning system catches this before an arrest, not after 2 days in custody. The sheriff's tether unit should have checked the location against active bond orders before treating a police station visit as suspicious. The officer completing the report should have named an actual violated condition instead of the ambiguous phrase, police contact.
Telling us what the police contact is. I don't know what the Third Circuit warrant is. I'm looking at his lien. Now, granted, this one is dated March the 28th, so maybe you need to update that, Lisa. But I don't see anything on here on his criminal history indicating any other charge emanated after the February 21 of 23 incident. So why don't you start by running his lien again, an updated version? I know it's only 8-9 days, but
can I say something?
Maybe that.
McNally orders an updated lien search. The Law Enforcement Information Network is Michigan's statewide system for criminal justice information, including records that can help officials determine whether a person is wanted on another matter. By this point, the court has not
And the intake process that classified Elliot into custody status should have flagged that the only supporting document contained no identified breach at all. Every one of those failures compounded into 38 hours, a lost paycheck, and a man standing in a courtroom asking a judge to explain why he was in handcuffs. As for accountability, the record shows no indication that any officer or agency involved faced review or consequence. The correction here was procedural, not disciplinary. The second legal issue at play is what element actually has to be established before someone can be held on a tether violation: an identified, specific breach of a bond condition, not a general sense that a location looked wrong. Most people assume that once a monitoring alert or a warrant appears on a screen, an arrest that follows must be legitimate. That isn't what the law requires. A record has to connect a location to an actual violated order. And here, nothing ever did. McNally didn't wait for a full hearing to correct it. "Somebody made an assumption," he said, "and my father used to tell me what happens when you make an assumption." He ordered Elliot released immediately, with no valid hold identified anywhere in the system.
Wait, do we have any indication that he has any other case pending in Wayne County Circuit Court, the Deputy Marquez?
No, sir, not that I see. None but the current stuff.
Lisa, do you have any indication on anything, including the lien that you're either have run or are running or about to run, that there's any other hold?
No, the lien is printing down there in the courtroom right now. And I looked on the Wayne County site. It only shows these 2 cases it's held on.
So the problem is somebody had made an assumption, and my father used to tell me what would happen if you made an assumption, and it's not a good one. This guy's been sitting in jail for 2 days. Unless there's a hold, I want him released immediately.
Thank you, Judge.
Okay?
No tether?
Well, no, he's still going to have his tether. I still want the tether on him. Wait.
Yes, Judge.
I want the tether on him still with the same tether conditions.
He kept the original bond conditions in place: GPS monitor, no contact, no alcohol, no weapons, because the underlying domestic violence case was still pending and unresolved. This wasn't an acquittal or a dismissal. It was a correction of an unauthorized 38 hours that should never have happened.
Turns from the legal decision to the human cost of the mistake.
Do you still have the tether right now, Mr. Elliott?
No, they cut it off, Your Honor.
So they need to get that back on him with those same conditions. And would you tell them the judge would really appreciate it if they would expedite it, since he's just spent 48 hours in jail, or if thereabouts 38 hours in jail that he shouldn't have spent 38 seconds on?
Yes,
So-
Your Honor, I'll get with my sergeant ASAP.
So Lisa, let's send that back. The minimus, we'll just do an amendment and say the defendant has posted bond.
The principle underneath that ruling is the same one that sits at the heart of due process law generally, the balancing test from Mathews v. Eldridge. Before the government takes someone's liberty, the record has to actually support it. A hunch dressed up as a report doesn't clear that bar. A man can follow a judge's own order to the letter and still end up in handcuffs if nobody checks the paperwork against reality. That's not a rare glitch in the system. It's what happens when monitoring technology gets treated as proof instead of a starting point. For anyone who's ever been on probation, pretrial release, or simply trusted a government system to get the details right, this case is a reminder that the burden of verification belongs to the state, not the person wearing the monitor.
It appears that was in error. Defendant to be released immediately, but I need you to have those. But this is not right. Look, they got to be more careful down there. I mean, this guy now, he spent 38 hours in jail. I wouldn't want to spend 38 seconds in jail, let alone 38 hours. Now, he's got himself into trouble, but he still enjoys a presumption of innocence here. And now somebody's going to tell me they can't get the tether back on for a day or 2 or 6, and that isn't right either. So do whatever you got to do.
Next time, we're looking at a case where a monitoring device wasn't the problem. The officer reading it was, and what happened when a defense attorney proved it on cross-examination. Was this 38-hour detention the result of one officer's failure to double check a report before acting on it? Or is it evidence of a monitoring system that's structurally built to treat location data as guilt first and ask questions later? And if it's the latter, what would actually fix it?